So I do want to open this to questions from all of you, but I'm gonna take the moderator's privilege and suggest that I have to imagine that the chase with the bear was not one in which one thought that the other was the only person engaging in it. I have to imagine Justice Breyer thought that he was running, even if not necessarily at warp speed. So I want to give through just an opportunity to talk a little bit about what he thought he was, how well he thought he was performing while they're both being chased by the bear.
Yeah. So Justice Breyer is actually a pretty competitive guy, and I don't know if, like Justice Scalia, he's ever held or fired a gun. Justice Scalia has. He has lots of adornments in his chambers that are proof of it. But in any competition, running from bears or drafting opinions, Justice Breyer takes that process seriously. I commented during the morning session. It's a thing for you guys to know that there's some law professor out there who did an article about how funny the justices are, and they actually looked at the transcripts of the oral arguments, and they would do a search for the word laughter in like parentheses, and Justice Scalia, according to that very careful study, is the funniest justice of all. Justice Breyer is second, and he does not like that. And ever since that article came out, you can see an uptick in his efforts to be funny. He also, I think, wrote the book Active Liberty a few years ago in response to the fact that he realized that folks that were in the camp that Justice Scalia and Justice Thomas, in some respects, lead, were being very convincing to the next generation of law students and lawyers. He realized that people would read these opinions, and there was an intuitiveness to saying, look, we shouldn't make judgments based on our own personal preferences. We should look at the text, and we should look at what the original framers and the original legislators wanted, and we should do what they want, not what we want. And Justice Breyer thought that's a very appealing explanation for what Justice Scalia and Justice Thomas is doing. And it's not that he thinks it was an exercise in bad faith, not at all. I think he very much appreciates that that is what they are trying to accomplish. For Justice Breyer, the concern was that that sometimes led to really troubling and damaging results, because sometimes what a textual argument suggested was really contrary to the individual rights that were at stake. Sometimes if you looked at just what people 227 years wanted, that would be very, very contrary to the overarching purpose of putting a constitution on paper, but also having a foundation that understood that judges would have to interpret it and apply it over many, many years, decades, centuries. And so he wanted to explain that for all the salesmanship of Justice Scalia and Justice Thomas in getting the message out, he wanted to make sure that there was another message, another explanation for why you could come up with a coherent theory for why you come up with these results. And instead of saying we should always look to see what the words on the page mean, especially because sometimes the words conflict and there's good arguments on both sides, and those are the hard cases, he said what we should do is always, in those really tough cases, think what will advance democracy, what will advance democratic discourse and debate and discussion. And that was his effort to outrun the bear.
I should just add that I think in an actual foot race, I would probably put my money on Justice Breyer.
Justice Scalia fights dirty. I wouldn't put it past him.
That is true.
Trip him or something.
Very scrappy. But I think Justice Breyer actually jogged with his law clerks when I was there. So.
And in fact, if one remembers, before Ruth Bader Ginsburg was appointed to the Supreme Court, Justice Breyer was considered for that seat. He got the next seat. But he went to the White House and had an interview with President Clinton, and the two of them went running together. So it's not clear whether running has benefited or harmed Justice Breyer, but it didn't harm him enough that it prevented him from getting on the Supreme Court. He just didn't win the first race. Apparently, Ruth Bader Ginsburg outran him. Which, in any event, so I would like to open this up for some questions from the forum. We do have a mic, so if you have questions, Arthur will bring the mic to you. Please, don't be shy. And I've got some, by the way, I'm not texting or emailing here. Professor Kulish and I have a very elaborate arrangement whereby he is sending me questions that are coming in real time. What's that? Okay, so one question that I have is,
This is so high-tech.
this is very high tech.
they
This
tweeting?
is quite impressive.
Are they tweeting
this
the
is a nice question. What effect, if any, or what influence, if any, do the books have on the court's opinions? And I'll moderate. What effect, if any, might these books have not just on Supreme Court opinions, but on lower court opinions? And I'll throw that out.
I mean, I think on the Supreme Court, the things that Justice Breyer, Justice Scalia, Justice Stevens is now retired, but, still, Justice Stevens are writing their book, are things that the other members of the Supreme Court are already very familiar with from having served with these justices for decades. And so, to a certain extent, I don't think the justices are trying to convince each other, and I don't think that the books are really moving the ball in Supreme Court cases, because the disagreements that, Justice Breyer isn't going to read Justice Scalia's book and be like, oh, finally, I
had it
see.
all wrong.
But I do think that with respect to lower courts and they can be very influential, judges who are still sort of forming their firm judicial views. And then I think taking a sort of step or 10 below that, I think the justices hope, and I think that books are very influential to law students and to young lawyers who, when you come to your first year of law school, you really don't have, at least I didn't, a firm opinion on the types of things we've been talking about. And you have to read these different well-developed views and figure out what you think for yourself. And I think they're trying to educate. All the justices are in that way.
I have two quick things to add. I think that's exactly right. The first is, do we have a hashtag?
Yes, we do.
Oh, nice. I've never had a hashtag before.
Hashtag is MLawCD.
Oh, nice. Oh, that's
I
exciting.
don't
That's
even know
very
what
exciting.
hashtag is. What is
I'm excited. The second thing is, I think to sort of riff off the last thing that Rebecca said, I think that, look, these books, insofar as they're going to influence the court, are a bank shot. And the bank shot is you guys. The bank shot is they're not writing for each other. They are not going to convince each other of what they think. The fight is for the future here. So what they're trying to do is they're trying to get the legal discourse set so that 20, 30, 40 years from now, the people that are being trained now, when they're in positions of power, are going to think what they think is right. So they are really, I think, writing for the future. Justice Stevens, in the introduction to his book, talks a lot about Constitution Day, the preamble. He says, a more perfect union. He says the Constitution's not perfect, but we're working on trying to make it more perfect. And I think that each one of these books is an attempt to make it more perfect by training lawyers, and young lawyers in particular, on their school of thought. So I think the books do aim to have an influence. It's just an influence that's going to be difficult to see right now, but look in 15 or 20 years, it could be a different matter.
I know you guys are still in college. Have any of you read an opinion by Justice Scalia? You guys had a chance to? So you should, when you get a chance, just pick any old case by Justice Scalia and take a quick look at it. It is a work of art. I mean, he's very, very persuasive, and especially for folks that haven't been through 3 years of law school and practice and seen the arguments and all the sides, especially, and it's not to say that their arguments are, weaker when you peel back the layer, although arguably they are. But at first blush, you will read these opinions, you'll find yourself almost nodding your head. You'll be like, yeah, that makes sense. That makes a lot of sense. Oh yeah, I can't even believe what the other side would be. And that's a really potent force to have on the Supreme Court. And I think a lot of commentators have noted what he has done to originalism and textualism. He's really given it sort of a really fun voice. He's like the cool hashtag guy for the Supreme Court. And it's something that I think other justices are trying to keep up with in some respects. And so I think I think Aaron and Rebecca are right. They're not necessarily talking to one another. I will just add one thing. It's a really interesting phenomenon. People talk about oral argument and what difference does it make for an advocate to be there and sort of making an argument at oral argument when so much briefing has happened in advance? And something that I think a lot of folks don't know is that the justices, almost as a matter of practice or tradition, very rarely will have any conversation among themselves about a case until after argument. And so at argument, there are 9 justices sitting there, all of whom have a view at that point because they've read the briefs and they've read bench memos and things like that. And this is their first opportunity in some sense to try to convince one another and to sort of lobby for a particular position. So you'll find that the advocates and the questions they ask are not really questions to the advocate, and the really good advocates know this. It's actually a question that is directed at Justice Kennedy or directed at Justice Stevens, but the advocate is supposed to be the mouthpiece for that. So Justice Breyer will say, well, wouldn't you say, and then fill in something that he thinks is going to be persuasive to Justice Kennedy, and the advocate's going to say, absolutely right, and the really good ones, they look to Justice Kennedy in answering the question, because they know that the audience of that particular conversation is at that point one another.
I should add, if you know, there are many, many Supreme Court opinions. If you want to read a particularly sort of fun, provocative opinion by Justice Scalia, Casey versus Planned Parenthood of Southeastern Pennsylvania, there's a partial concurrence, partial dissent by Justice Scalia that really is a very Scalia-esque drafting exercise. It is punchy, to say the least. And if you're looking for an example of what Theroux is talking about, that would be a nice one to pick. I could pick others, but that's one that I think you would probably get a good sense of his style from reading. Rebecca, would you agree with that choice?
I agree. I think my all-time favorite is the Morrison dissent.
Well,
This
right.
comes as a
The
wolf,
Morrison
but-
dissent, though, has a little less of the kind of rhetorical flourish. It's a wonderful piece of argumentation on its merits, but in terms of rhetorical flourish, I don't think it quite compares to Casey.
And for those of
Yeah.
us who sometimes disagree with Justice Scalia, this is really frustrating because it's like,
No, look, Scalia opinions are like onions. There's layer and layer that you can peel back, and the deeper you get, the more you want to cry. So,
So I've got a couple of questions the high-tech way, but I'd like to take some questions the low-tech way, especially from those of you who are here from College Park. Are there questions that you have? Don't be shy, please. Please.
There's no bad questions.
How would you say that the upbringing of all the justices had an effect on their decisions?
it's a great question. It's a really great question. Because I think that serving for a justice or working even for any employer, you realize that so much of what they do has to do with where they came from and sort of what their upbringing was. I'll just give one example. I know that Justice Breyer, his father was a lawyer for the school board in San Francisco. And I think that's one of the reasons why he took so seriously the rights of school boards and local districts to come up with their own governance strategies for combating the problems that they had. I don't know that they're any different than anyone else. You really do sort of, life is so autobiographical in that respect. Is the things that matter to you have so much to do with the things that you've gone through and that you've experienced. That's just sort of one example. It's a really great question. I wish I had a better example, but I think it very much does shape their views.
yeah, I agree. I mean, not in the sense that I think someone says consciously, you know, oh, I did such and such growing up, therefore I think X, but we're obviously all compilations of our lived experiences. There's no way around that. In the context of Justice Stevens, something that he's spoken about is he was the last member of the court to have military service when he was on the bench. He served in World War II. He likes to say he enlisted and the Japanese responded the next day by bombing Pearl Harbor. And he was actually on the code-breaking team that tracked Yamamoto's plane in World War II. But he's spoken a couple of times about military experience and the way that that's sort of impacted his view on, you know, not necessarily in ways you would expect. Sometimes giving more of a solicitude for the military, sometimes saying, you know, well, I don't buy the military kind of inflating its problems here that's going to arise from this. So I think that without a doubt, because there are only so many hours in a day, there's only so many days in a lifetime, I think your experiences certainly influence it. I was talking recently with a clerk from a justice who had discussed how when Justice Marshall, Thurgood Marshall, first African-American member of the court, when he joined the court, that really had a fundamental change in the nature of discussion that was going on, because there were, before that, 9 white men that came from basically upper or upper middle class backgrounds on the court. And all of a sudden, there was a black man that had been part of the civil rights movement. And there's just no way that couldn't have contributed a richness and an understanding of what was going on.
Just want to add one interesting datum. The question of upbringing is interesting, but as Aaron points out, the question of life experience is also interesting. One of the reasons why Justice Powell was supportive of a right to abort was that it happened to be the case that his father-in-law was an obstetrician. And so from his life experience in dealing with his father-in-law, he viewed it as a medical decision. He really believed it was a question of sort of medical judgment working in consultation with the woman who was the patient of the obstetrician. And there's no doubt that the women who have served on the court, right, Sandra Day O'Connor, Ruth Bader Ginsburg, Alana Kagan, Sonia Sotomayor, that their life experience growing up as women it had to have affected the nature of the way they look at any broad number of issues dealing specifically with women, but I think it would be naive to imagine it's limited to that, right, because of the different experiences that men versus women have, and obviously it relates to race as well.
And if I can add just another example, this is a provocative example, but it's a public example. Justice Thomas is the oftentimes votes, I think almost always has voted in decisions against race-conscious admissions, affirmative action, at really any level, and he has publicly spoken about his experiences coming out of Yale Law School, considering himself a very, very good candidate, and convinced himself, and he's publicly spoken about the fact that he couldn't get jobs at law firms, even though he was a great student at a great law school. And a lot of people would say, gosh, that's an example of why affirmative action or race-conscious admissions is useful, because then to overcome the racial prejudice, you would have been given a chance at some of those institutions. His autobiographical account of it is that because those people assumed that he had gotten to Yale Law School because of affirmative action, they would not judge him on the merits, and he therefore couldn't get jobs. And he's publicly spoken about how that was a defining experience for him, and that no doubt, I think, has played a role in his thinking, even as an African-American justice on the Supreme Court, as an opponent of things like race-conscious admissions and affirmative action.
So I have a question, the high-tech way. Is the more effective justice one who is a scholar or one who is an effective political maneuverer on the court? There's a second question from the same person, but let's talk about that. What do you think?
I think one thing to note is that, we've been talking about the justices as like scholars in writing their books and as judges in the court, but actually all of their judicial work is really quite scholarly. They have to dig into these brand new areas of law and fact all the time, and they rely heavily on the work of law professors and experts, and they're really sort of engaged with the academy. And I think it is impossible to do the job well and persuasively to your colleagues without that sort of deep substantive scholarship aspect. No amount of, at least I think on today's court, it's fair to say, almost no amount of sort of political maneuvering or friendship or alliances with other justices will compensate for a lack of precedent and depth in scholarly analysis. That being said, it's certainly, I guess one trope about today's court is that Justice Kennedy is often the swing vote and, can often go either way and often sort of makes the difference in a 5-4 case, and it's hard to tell which way he's going to go until he's gone. And I think it's fair. and so
Some people say.
Some people say.
Some might say. And so you definitely see some people You just see this in lawyers, the way they make their arguments, and in law, and the justices, when they try to persuade each other, you see them sort of couching their scholarly and their legal arguments in a way that may seem appealing to Justice Kennedy. And I think that is sort of a more of a political maneuvering, and that is just an artifact of the way the court is lined up and Justice Kennedy's position in the middle.
Great, we have a question in the front row. No, he's going to give you the mic so that we can all hear you. Thank you.
Actually branches off his life experience question. While I was listening, I heard lots of your backgrounds, mainly Yale. And I'm sure, like, not that Harvard's not good, but and that I think I want to know do the judges you serve, do they have the same, Ivy League background? And if they do, does that kind of like constrain their life experiences? Because not that, the Yale isn't good, but it kind of like, it's kind of like a small community and a small, like, does that kind of small community shape their life experience and their decisions?
That's a good question.
Yeah, I think the answer is yes. I think it's a problem that we have all justices at this point that have graduated from the same two law schools. I'm not sure.
Stevens is Northwestern.
Right, with the exception of John Paul Stevens, who, well, he's not on the court, but when he was there, he went to Northwestern Law School. And Justice Stevens has said publicly that he thinks we could do with a little more diversity. Now, that being said, I loved Yale, grew up in New Haven, it's a great place. But look, there's nothing particularly brilliant in the water there about what they're doing. Lots of great justices that have come from lots of different schools. In fact, everyone's favorite justice of the 20th century is Justice Jackson, Robert Jackson, who, interesting fact, was actually our last justice who didn't graduate from law school. Now, he attended Albany for a little bit, but he didn't graduate from law school. So I think that my own personal position is that it wouldn't be so bad. There are lots of different kinds of diversity. I think one of the reasons that you see that right now is because when they go down the list in the confirmation process, they're trying to find as few holes as possible, so they figure that's a safe bet. I would bet, and I could be wrong, but I would bet that of the next two justices, regardless of who makes the appointment, Democrat or Republican, that you will get at least one that did not come from Harvard or Yale Law School. And I think that will be, it'll be good. I mean, it has to be, right? Getting more perspectives for the court, I think would be helpful.
I just should say that the Yale thing among the three of us is a little bit of just a weird coincidence, too. Like, law clerks did not all go to Yale by any means, college or law school. I think it's probably fair to say that Justice Scalia himself does not think terribly much of Yale Law School in its sort of rigor in preparing students for the actual practice of law, and in some ways fairly so. So this is a little weird, but.
And I actually, it's a really good question, and it's important actually not to be distracted by the credentials that they ended with, because their upbringings are also very interesting. And I would worry more about the upbringings that they have had and the fact that there is some diversity, but not as much as one might sort of expect. It was very recently, it was Justice Kagan, who was the first justice on the court that was not a circuit court judge immediately before that. And so she had been a judge all of the justices had been judges for a long time before that. And in order to become judges, you sometimes go to fancier law schools. But the fact that, Sonia Sotomayor had a very, tough upbringing in New York, that I actually think is very valuable. And each of the three of us have, very different backgrounds before college and before law school. And I sort of think that it's really important to sort of appreciate the ways in which diversity can sort of play themselves out. And yeah, when we're sort of making the joke that I'm the minority here because I went to Harvard, that's a weird joke to make. But it's really important to realize that, and a lot of us have sort of talked about teaching at this law school and at other law schools. I teach at University of Baltimore Law School up the street at the University of Maryland, and we're talking about this at lunch about how the very best students from these schools are as good as the very best students at any school in the country. And so, although certainly doors have opened for me personally that might not have been open had I not gone to the schools that I went to. Gosh, I'd trade, my top student at UB or my top student at Maryland for a half dozen, friends of mine at my law school, just because that's just the nature of law schools. Now there's so many law schools and there's so many considerations that go into it. So it's a real mistake to make the assumption on the basis of the law school that those are the right people or the best people. Thankfully, there is more to each of them than the places that they graduated from law school, which are really in the middle of their careers, right? Doesn't reflect all the amazing things that they did afterwards or all of the amazing things that got them to get to go to those schools.
And the one other thing I'd say is you can also cut it lots of different ways. So, for instance, right now the court is missing a Westerner. There's nobody from west of the Mississippi, really. The other thing, the court has 4 members of the court that are from 4 of the 5 boroughs of New York City. So maybe it's time to get someone from Staten Island on the court. But there are, as Drew said, a lot of different ways of looking at it too, diversity.
I'm going to make a plug for the University of Maryland. It so happens that I clerked on the same court that Dean Tobin clerked on. I clerked for Judge Harrison Winter, who the year that I clerked for him, which was 1987 to 88, was the chief judge of that court, and he was a graduate of this very law school, not this very building, but this very law school. And there are many graduates of this excellent law school that are judges, not only in the Maryland system. I just want to, especially for undergraduates, I don't want you to come away with the impression that the only sort of movers and shakers in the legal profession are graduates of Yale or Harvard Law School. That is not true. There are many outstanding lawyers that come from law schools throughout the country, including this one, including Baltimore, which was mentioned, and including many others who have gone on to have spectacular careers, and I don't mean just in terms of making a good living, but I mean in terms of doing good work. And that's really important to convey. I don't want you to come away with a misimpression about that. What makes somebody successful in this profession or any other, I don't care what you decide you want to do, what makes somebody successful in any profession is a deep passion for what it is you want to do. That's what drives you. Sure, it's nice to have the credential, but the fact is you can, with passion, succeed in whatever you choose, and it's just important to know that. I have another question the high-tech way, but I'd love to take another one from here.
Yeah, I'm just curious about when we went through and everybody said, where they went to school and everything. You all mentioned that you were part of law reviews, journals in college, and I know that those are very important for postgraduate work, even getting your positions as Supreme Court aides like that. But when you're there and you're actually doing that work for those journals and those reviews, what did you get out of it? Because I know that they're important for resumes, but obviously you did it for other reasons than that. So what did you experience?
Are you in college or law school, by the way? I had no idea what a law review was when I was in college. That's either super cool or super nerdy.
I mean, so Becca and I were both we were both articles editors of the Yale Law Journal together. Look, the first year, the first thing is don't worry about this. That's the first thing. Right now, definitely not something to worry about at this point if you're an undergrad. So come back in a couple of years. But let's take the time warp. Look, the first year of law review was really boring for me. We were doing like really boring stuff. Basically, it involves like cite checking, which means you need to look something up to make sure that the citation is what it purports to be. And you have to make sure it's properly formatted. This is really, really boring. It also turns out to be like actually a not unimportant skill. Not so much making sure it's properly formatted, but actually making sure that something says what it purports to say is actually an important lawyerly blocking and tackling skill. Just like in football, nobody enjoys hitting the sled over and over and over. It's boring. But it actually is good technique because a lot of what you do as a lawyer is, look, at this stage, particularly like when we were clerking at the court, if you put in a citation, then it better say what you think it says. Because if it doesn't, it's going to be, they go over those with a fine-tooth comb. It's a boring, but I think ultimately skill that was worth obtaining. The second year, when we were articles editors, was much more interesting. You got to read lots of law review articles. To some people, this is great, like me. I'm a law dork. To some people, this is awful. You shouldn't be an articles editor, but you got to read a lot of articles, like hundreds. It was almost like the circ pool coming in. There are all these articles coming over the transom. We used to meet like
3 times a week,
three
for
times
2
a
hours
week.
each.
Yeah, for hours and hours. We would like get dinner and sit there and debate articles. And then you get to actually work with some of the professors in the editing process. So that was really cool. So the first year was blocking and tackling, and the second year was interesting stuff.
So I've got an interesting question here, and I'm not sure how easy this is going to be for any of you to answer, but we'll give it a go. So it says, I'm going to slightly rephrase it. In any particular case, is there a big question that would be asked by Breyer, Scalia, or Stevens that would serve to readily distinguish their differing judicial philosophies? Are there particular questions that they're prone to ask in the same case that reveal something profound about the way they look at things?
That's a highly sophisticated question.
It is.
That's pretty good. So I will say, and I'll sort of say this a little bit in jest, Justice Breyer is oftentimes caricatured for his hypotheticals. He asks these crazy, winding, off-the-wall, colorful sometimes, weird sometimes, hypotheticals. And, there's been parodies done of his references to mushrooms and squirrels and all these kind of crazy questions. There was a case about a strip search of a student, and he was trying to ask it as a hypothetical, and his hypothetical wasn't working, so he used himself in the hypothetical, and he started saying, well, just imagine if I had been hiding something in my underwear, and his brother called him up, who's a judge in California, and said, don't you ever do that again, you're making our family look bad. And so he asked these, off-the-wall hypotheticals. It is revealing that he is so prone to go to hypotheticals. Part of that has to do with the fact that he was a law professor, and the Socratic method in law school is so much based on, you've got your case, tell me how that case would apply to this hypothetical scenario. That's the way to sort of test and stretch the doctrine. So it's the law professor in him. The other part of for, I think, Justice Breyer, in my view, is that it's him trying to make it clear to the other justices as well as the advocates that this case has to be applied, that our decision has to be applied in a lot of different contexts. And if we apply the law in a very different context and it results in something a little crazy, then maybe we'd really ought to reconsider going that direction with the law. I think for him it's his sort of pragmatic approach to the law, that this decision not only has to answer this case, it certainly does, and that's the most important and paramount consideration, but it also needs to be a workable doctrine for lots of different contexts, including my zany, off-the-wall hypotheticals. And so that's my best answer.
Yeah, I mean, I think I don't have a fun hypothetical, but I think one thing that really differentiates like a Justice Scalia from a Justice Breyer are the questions that they ask in each case. Both the order in which they ask those questions and sort of like where they stop and which ones they focus on. And so, in a case that involves the application of a federal statute, Justice Scalia will ask, what does the text say? What does that mean? He will read sort of the entire statute to understand the context in which the particular provision at issue, comes about. And he will read judicial precedents and ask about sort of how courts have interpreted the statute. But what he will not do is go on to ask, what did the legislators say about how the statute might work when they were debating it on the floor of Congress? Or, what did the Congress that passed this statute have in its mind about how it would apply to particular settings? And, those are basically, and you'll see this in briefs, so, advocates know that some justices are asking some questions and some are asking others, and they'll sort of structure their briefs in ways where the justices can quickly focus on the sections that are most interesting to them. So, for example, a brief will always have a legislative history section about what people said on the floor of Congress when they're passing a bill, but it's often like a contained thing, and, you know, I mean, the justice reads everything, but he knows as soon as he gets to that section that that's really a section targeted Justice Breyer.
So
And-
he skips it.
To answer the question, sort of not answer it, so I didn't see Justice Stevens on the bench, right? He doesn't sit anymore. But I would say, from my understanding of Justice Stevens, the most important question he usually asked was the first one of his sort of order of questions. He's actually a quieter person. His character is a little more reticent. He often lets a bunch, not as quiet as Justice Thomas, who doesn't ask any questions, but on the quiet side. He's kind of a quiet guy, and he would often let a lot of people ask questions. And then if there was still something that he thought was unclear or a weakness, then he would ask the question. So by the time you got down to it, if he was asking you a question, advocates described, and from sort of both sides of the aisle, opposite views, that it often was like a laser, like right at what the issue was. So often the first question that Justice Stevens asked was the most important. In terms of Justice Kennedy, for whom I did see a lot of oral argument, in the same way that Justice Breyer and Justice Scalia have different kind of pillars of their jurisprudence, I think Justice Kennedy's jurisprudence, he tends to care a lot about individual liberty and a lot about freedom. And so you'll often hear him asking questions and have briefs that are targeted at those particular, sometimes you can even count the words when you look through and you're like, here now they're getting to the Justice Kennedy argument. But I think that questions about the sort of individual freedom, liberty, and dignity are the ones that really sort of reflect his jurisprudence.
So I think we have time for one more question before we break. Please.
Hi. So the whole idea of law reviews and different associations and things like that can seem a bit overwhelming sometimes. But as students who are just beginning our undergraduate careers, what would you say we should be worrying about and focusing on, like, right now?
I'm happy to offer a couple of reflections on that. Having taught law school for a pretty long time, 22 years, and students with all kinds of varied undergraduate backgrounds. And I can say this, and I really sincerely believe it, you can pretty much study anything, come to law school, and excel. I have a list of preferred things that I advise people sometimes to, you know, if they're open-minded about what they want to study, I think there are particular fields that are worth considering. But I've had students excel in tremendously varied majors. I've had students who are engineers. I've had students who were medical doctors before they came to law school. I've had students who were architects or architecture majors before they came to law school. Political science, economics, English, runs the gamut. The most important thing is to find the thing that excites you and pursue it vigorously. Because that's really what you're going to take into law school, is that level of attention to detail, broad understanding, intellectual curiosity, and drive. That's what matters. Don't worry, if you're thinking about law school, about the relationship between what you're doing as an undergraduate and your legal studies. That's my first piece of advice. Focus on what excites you, take it seriously, be engaged in your community, and be a serious student. I mean, that's my best advice.
I think that's really great advice. I was essentially a math major in college.
I've had those too.
And I wrote my law school application about math, and it's what I really liked in law school. It's what I really liked in college. Even though I knew all along that I was going to be a lawyer and I wanted to go to law school, I will tell you, and this was for me a really hard transition, I was not a very good writer when I started college. I think of myself as a good writer now, but I struggled as a writer when I first started college, and it was something I really had to work on. And it was something I didn't really work on until late college. But I think taking the time in these, wonderful, great years where you can both party and make friends, but also have a moment to exercise the muscles that are needed to be a good writer, it's a great way to spend some time. So if you can find opportunities to write and sort of find your voice and find confidence in your voice, I think that can make a really big difference. I didn't get that until much later, and I know I wish I'd had it earlier.
Yeah, I mean, I totally agree with that. You know, your path does not have to be sort of a straight arrow by any means. When I was in college, I sort of resisted the idea of being a lawyer because both of my parents are lawyers, and I was like, I could think of something else to do, right? And I was an investment banker after college, and I hated that so much, and I quit it after a year. I moved to a horse farm, and I became a professional horseback rider. Then I went to India for a long time, and then finally I just caved and went to law school. And so it can work out. But the unifying theme is that each time I was picking something that I thought I was going to love, it turned out I did love the horseback riding, I'm just not good enough to do it professionally, but, and finally I sort of settled on where I am now, but it's not a straight road.
Yeah, I'm with, oh, sorry, David. Well, it might be a while, no, I'm just kidding. I'm with Becca. Before going to law school, the year that I had between college and law school, I was actually a deckhand on a sailboat on a tall ship in Brazil. And I would have stayed there. It just turns out you can't make a living as a sailboat deckhand, unfortunately. So I became a lawyer. But I do think that the most important thing is, as Professor Stern said, find something you're passionate about and you care about. And I think that the instrumental wrinkle to that is you'll do better in it too. I mean, if you really care about it and you're interested in it, you're going to do better. And I know it sounds kind of like the party line or whatever, but it's really true. If you really enjoy the academic area you're in, you're going to be more successful. Now look, that takes you only so far. If it were up to me right now, I would be the closer for the Boston Red Sox. But, at some point you have to say you have strengths and weaknesses.
This year you might be able to do that.
Right, exactly. It's looking good. I'm waiting. It could be last game of the season. I'm waiting for the call. I think the one other skill-based thing I would add is in addition to writing, and I think writing is really important to learn how to write, is reading is also a really important skill. And you can get that in almost any discipline that you're studying in college. If I went back and redid it for a little bit in college, I used to be very proud that I could read not that much and sort of bluff my way through what I was doing. And I was very proud of this. And I think I shortchanged myself out of a bit of an education that way. I kind of got the point after a little while, but even if you can hit the sort of instrumental, you're getting good grades, you're doing fine and that sort of thing, you want to learn how to read because that's also a skill. Learning how to read carefully, learning how to get through a decent amount of material and really understand it deeply is a skill, and you're not going to really have any other time in your life where you're just going to have lots of time to sit down and struggle with things. So in addition to writing, I would say work on reading.
We do need to break, but I can't resist making this one last comment. David, do you have a question?
I wanted to add something.
Oh, go ahead.
Comments, which is take some time to develop close working relationships with your professors. That's something that undergraduate students and even law students too often miss the opportunity to develop close working relationships with their professors. Because one of the things that's left out of the bios of all the justices and the people on the panel is that somebody had their back at a critical moment. At a critical moment, a phone call was made and somebody said, hey, this is the Rue guy, what can you tell me about it? And somebody was in a position to say substantive things about what the Rue can do because they have deep working relationships with the Rue. And so make sure that you don't miss the opportunity to develop close working relationships with your professors. It's also a skill, making those kinds of professional relationships, and it's one that will carry you the rest of your life and career. And it's also fun, because we turn out to be, at least hopefully, warm, engaging, interesting people.
I couldn't agree more. That's great advice. The one thing that I was going to just add to all of this, and I just really encourage you, absolutely read, absolutely work in your writing. When you're reading, read things that challenge your thinking, not just things that reinforce what you already think you know, right? For example, in reading the newspaper, find columnists who you are inclined to think you disagree with and read them regularly, in addition to the ones that you're inclined to think you do agree with. It'll make you smarter. It'll make you sharper. It may not change your opinion, but it will make your opinion more thoughtful and informed, and that ultimately will make you better at whatever you do. I want to thank you all for coming. I want to thank the panelists especially, and we will have a chance to chat informally out of the moot courtroom. Thank you.